believe you're entitled to 10 minutes of oral argument. If you wouldn't mind putting your name on the record, please.
I'm the executor and sole beneficiary of the trust and estate of Mr. Kevin Dwayne Craft, the legal persona.
Well, Mr. Kevin Dwayne Craft, the legal person, how silly are you going to be today? Hey everyone, welcome to today's video. Today, we're talking about a sovereign citizen who did something crazy. He took his case all the way to the Michigan Court of Appeals. But it's not about the usual rights like traveling freely or other common sovereign citizen issues. Instead, he's fighting for the right to be a deadbeat dad, saying the state can't make him take care of his kids.
I'm not here making a general appearance. I'm here by special divine appearance, judge, to settle a matter, to call for a constitutional court of record to ask for a summary judgment upon the truth and facts that I placed upon the record with my documents. I stand firmly on my rights, and I'm here to ask for that summary judgment, please.
You've asked for.
I do also have a few questions.
I understand you're pro se, and then therefore you get a little bit of leeway, but typically the judges don't answer questions. We're the ones who ask questions. This isn't like a trial court where it's a very kind of back and forth. The Court of Appeals is more structured in terms of the lawyers or parties come up, they make their arguments. The judges may or may not have questions for the person, and then it's submitted, and then we go back and discuss the matter, and then at some point in the future we come out with an opinion. So it is different in that respect than trial court.
Understood. But I am wondering if this is a court of constitution, and would the Constitution be applied in these proceedings?
The Court of Appeals, the Michigan Court of Appeals, is provided for under the state Constitution of 1963.
Is that a yes?
That's the answer I'm giving you.
Okay. I'm asking to verify to make sure these proceedings are legitimate. The Constitution has two jurisdictions: common law, admiralty law, or maritime tribunal. And I'm asking in which context would this court try to enforce jurisdiction on me?
Wait a minute. You're the one who took this case to the Michigan Court of Appeals. Now you're arguing if they have the power to decide. To answer your question, the court's power over you comes from both personal and legal authority. It's written in the United States Constitution and the Michigan State Constitution.
We're acting under the state Constitution of Michigan of 1963.
Moving forward, I'm here to pretty much address the court's error for ignoring my motions. Notice of dismissal, default judgment under Federal Rule 55 was filed December 12, 2022. Under Federal Rule 55, if a party fails to respond to the defendants themselves, and this is confirmed by my affidavits, and other means, the clerk must officially record a default judgment of that party. I filed several motions and they were ignored. That's why I'm here. In Haynes versus Kennar, 404 U.S. 519, 1972, courts must be understanding and not easily reject motions from people just representing themselves. And that's what took place in this matter.
But is that really true? In the case Haynes versus Kerner, the court said that you can't just ignore defendants' claims about civil rights violations without letting them prove it. That I'm sure you probably filed a lot of pointless motions, and they were all likely denied. Yet, in your confused state, you somehow thought your situation was a real civil rights violation.
In Article 1, Section 17 of the Michigan Constitution prevents courts from ignoring motions and guarantees that people have a fair chance to represent themselves in any argument and evidence. That did not happen. That's why we're here. The state ordered me to take a paternity test. And Monell versus Department of Social Services, which is a New York State case. The Supreme Court case established that municipalities' liability under the Section 1983 for constitutional violations in the context of child support cases where the appellant argues that a warrant should be required for me obtaining genetic and biological material. I think it's very sensitive when a state injects an order asking me to give genetic and biological material without a warrant. That's really sensitive material. It's not like a document or anything. That's personal biological material. That's why those specimens were not granted. That's why I deny any consent of any contract with the state or Title 4D agency to give away my biological and genetic material.
Oh, so this is what it's really about. You don't want to take care of your kids or pay child support. So you went full sovereign citizen.
That the case Monell is relevant because it underscores the importance to ensure that government agencies like the Friend of the Court on this context, these are for-profit agencies disguised as government agencies like the Friend of the Court, adhere to constitutional standards where collecting evidence potentially implying the need of procedure safeguards to protect individuals' Fourth Amendment. That's why I asked, was this a constitutional court? The asking for genetic material is protected by my Fourth Amendment right. The Fourth Amendment protects individuals from unreasonable searches and seizures and safeguards one's privacy and assurance that any such search is conducted within the boundaries of legal requirements.
Well, here's your first problem. Michigan's Law Code Act 205, or the Parenting Act, says a state has a right to get your DNA in cases like this. The IT also explains how they can collect your DNA and what happens if you refuse to cooperate.
I see that they're not here today, and that's some questions that are raised, and those were my concerns. On August 11, 2022, the Kent County ordered an appointment for me for genetic and biological testing. In a testing laboratory, DNA Diagnosis Center is a business, and I can prove it's a business because I have their Dun and Bradstreet numbers, 877-184226 for the record. They also said, when I thought this was funny, the state of Michigan stated that it would pay the cost of the genetic test, and if I wasn't excluded, that I would be responsible for that cost. And with that being said, that set alarm.
Let me guess. You got worried because it's going to cost you more money, and they are still going to find out the truth about you.
The state of Michigan is also a business. And with them fronting the cost for me, that presented an alarm for me because I don't choose the contract with the state of Michigan. I don't choose to do business with them in this regard with another business. It seems like a coercion of some sort for them to upfront the cost if I was going to be responsible. I do not consent to that business arrangement. The state, they failed to show a promissory note of a contract of any sort. I submitted documents, notice to the court to demand dismissal for lack of jurisdiction, demanded to see an open court evidence of personal and subject matter jurisdiction, and notice of court to refusing to appear voluntary. And I do not accept the offer to contract, and I do not consent to these proceedings. That affidavit or notice to motion was submitted on November 28th, 2022. So again, I'm just bringing up the point that I submitted numerous of documents asking for clear evidence or asking for due process, also asking for quite frankly, to be transparent with what's happening. And I believe I deserve the right to see in writing what gives them the authority and what contract am I entering. I want full disclosure.